The Working Party 29's position paper on the derogations from the obligation to maintain records of processing activities under Article 30(5) of the GDPR provides essential guidance for controllers and processors, especially in the context of small and medium-sized enterprises, SMEs. This paper underscores the importance of compliance with the GDPR's requirements for record keeping, while also recognizing the specific challenges faced by smaller organizations. Understanding Article 30(5) GDPR. Article 30 of the GDPR mandates that organizations maintain a detailed record of their processing activities. However, Article 30(5) introduces a derogation for organizations with fewer than 250 employees, acknowledging the disproportionate burden record-keeping could impose on smaller entities. This exemption is not absolute and comes with critical caveats aimed at protecting data subjects' rights and freedoms. Key points of the WP29 Position Paper. Clarification of derogations. The paper clarifies that the exemption under Article 30(5) does not apply unconditionally. 3 specific types of processing activities are outlined where the derogation does not apply. 1. Processing likely to result in a risk to the rights and freedoms of data subjects. 2. Processing that is not occasional. 3. Processing that includes special categories of data or data relating to criminal convictions and offenses. Criteria for exemption. The WP29 highlights that any one of the 3 conditions mentioned above suffices to require an organization to maintain records of processing activities. This clarification is critical for organizations that, despite having fewer than 250 employees, engage in processing activities that could impact data subjects' rights and freedoms. Implications for SMEs. The paper acknowledges that while maintaining a record of processing activities represents a new administrative requirement, it is not expected to be a significant burden for many SMEs. It underscores the record's utility in facilitating risk assessment and the implementation of appropriate security measures, aligning with the GDPR's principle of accountability. Support for SMEs. Recognizing the potential challenges, the WP29 encourages national supervisory authorities to assist SMEs by providing tools and resources to simplify the process of maintaining records of processing activities. Suggested supports include simplified models and guidelines available through supervisory authorities' websites. Practical recommendations for compliance. For SMEs, navigating the GDPR's requirements can seem daunting. However, the WP29 Position Paper provides clear guidance and practical steps to ensure compliance. 1. Assess processing activities. Regularly evaluate processing activities to determine if they fall within the exemptions specified in Article 30(5). 2. Maintain records when required. If processing activities do not qualify for derogation, maintain accurate and detailed records, as specified by the GDPR. 3. Utilize available resources. Take advantage of templates, guidelines, and other resources provided by supervisory authorities to simplify compliance efforts. 4. Prioritize data protection. Use the record of processing activities as a tool to assess risks and implement necessary security measures, reinforcing the organization's commitment to data protection and privacy. Conclusion. The Working Party 29's position paper on Article 30(5) GDPR serves as a valuable resource for SMEs, offering clarity on compliance obligations and practical advice on maintaining records of processing activities. By adhering to these guidelines, organizations can not only fulfill their legal requirements but also strengthen their data protection practices, ensuring a robust framework for protecting individuals' privacy rights.